Members of the jury, what I want you to do in this case is to use your common sense. You have heard a brilliant array of doctors and other witnesses, and the eloquence of that lawyer, but yours is the responsibility to decide this case. Talk about justice. There is no justice known here except justice in accordance with the law. If we obey the law, we will be doing justice. I am the law to you. If I make a mistake in the law, these lawyers know how to correct me. It is a much more difficult thing to correct a mistake that you make, but if you follow my instructions, you will be doing your full duty, and so far as you depart from my instructions, you are false to your duty. While the case from the plaintiff's point of view is a serious one, yet the evidence is not so difficult. There are two branches to it, as the lawyers have said. First, who caused the accident? The plaintiff must prove that he came to his initial injuries that he received because of the happening of this accident, that he received those injuries through the negligence of the defendant, and he must go further and prove that he himself was wholly free from negligence contributing to the accident. The burden rests upon the plaintiff. He is here asking you and me to give him a very large sum of money. Take it away from the defendant and hand it to him. The law is that the person asking the money of another, that it be taken from somebody else and handed to him, has the burden of proof. He must come in here before judge and jury and prove his case, as the law puts it, by a fair preponderance of the credible testimony. That is, testimony which appeals to your minds when viewed in the light of your common sense and practical experience as being more worthy of belief than the opposing testimony. When the testimony on behalf of the plaintiff is put in the scales as against the opposing testimony, the plaintiff's side of the scales must fairly outweigh, and in number of witnesses, not in mass of testimony, but in the quality of the testimony. Do not hope that you can reach certainty. There is almost nothing certain in this world, if you will stop to think about it. You gentlemen do not know what time you are going to get home tonight, and you do not know whether dinner will be ready for you in time either. Nevertheless, these controversies must be settled, or society would break down. Men would be taking the law in their own hands. This is the tribunal ordained by the Constitution and the laws for the settlement of these disputes. And I charge you that it is your duty to exert every reasonable means to reach an agreement, so that when we get through with the case, there will be an end of it and justice done, so far as we are able to do justice. If we do that, we will have done our full duty. The testimony is quite simple, relating to that accident that occurred. You have seen the witnesses all in this chair. You have heard them under direct and under cross-examination. You noted their appearance, their manner of testifying, and the story they told. How did it impress you when viewed in the light of your good old common sense? Where, in all reasonable probability, does the truth lie? How did this accident happen? The burden of proof is upon the plaintiff. He must show that the accident happened through the negligence of the defendant. He may show that by a fair preponderance of the credible testimony. He must further show that he himself was wholly free from negligence, contributing to the accident. That he must show by a fair preponderance of the credible testimony. No matter how negligent the defendant was, if his negligence contributed in the least degree to the accident, he cannot recover. Now, consider the testimony bearing upon the accident, all of the testimony. You are not obliged to believe nor to disbelieve a single witness that has testified from that chair if the testimony does not appeal to your minds, when viewed in the light of your common sense, as being worthy of belief. What we are after is the truth, as nearly as we can get it, as I said before, and shall say again, because I want to drive it into your minds, the truth. Of course, unless the plaintiff prevails upon that first branch of the case, he has lost entirely. Your verdict will be for the defendant. Naturally, we sympathize with this man. We would be inhuman if we did not. You can be just as sympathetic as you please, but you must be sympathetic at your own expense. There is no law forbidding you from going into your own pockets in order to show the goodness of your heart and how sympathetic you are by the size of the bill you hand out to the object of your sympathy. But do not vote somebody else's money to the object of your sympathy to show what good fellows you are. We must be governed by the facts. What are the reasonable probabilities? Where is the weight of evidence? Has the plaintiff proved the case?
Too fast. That's ours.